Meeting to order.
Notice hereby given that a joint meeting of the Board of Adjustment of the Town of Laguna Vista, Texas will be held Monday, 5:30 p.m. at City Hall located at 122 Miranda Street, East Texas. Members find the items will be discussed. Calling the order at 5:36.
Either chair may take us through the next agenda.
Go ahead.
Well, meetings were, we don't need to do a real roll call, do we?
We'll get to that first, a pledge of allegiance.
Okay, let's do a pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Texas flag is up.
Honor the Texas flag. I pledge allegiance to the Texas, one state, under God, one indivisible.
Yeah. We never said this. Until I got hit.
Yeah, we never did it.
I will do the roll call for the Board of Adjustments. Frank Alamo.
Here.
Felicia Justice. Here. Terry Bowles. Rafael Salazar.
Here.
Stanford Knowles.
Here.
Richard Engel.
Here.
For the Planning and Zoning, Stanford Knowles.
Here.
Myra Wood. Here. Terry Bowles. Frank Davalos.
Here.
Felicia Justice. Here. Lee West. Here. Richard Engel.
Here.
Mr. Knowles.
Open forum. Do we have anyone in the audience who's got 3 minutes per person to address the board on any topic? There's no discussion or formal action taken during this agenda item. The speaker may request forum must be presented to the city secretary in private meeting.
I was not presented any forms.
Okay. Okay, we'll open the workshop on the subdivision ordinance. I think we'll take one at a time.
Okay, just go ahead.
Yes.
Okay, so we got, members of the zoning board and the board of adjustments, some of you may know me already, Alan Ozuna, the town's attorney, and I also, as in that role, advise the town's subsidiary boards and the community development corporation. And so, the city manager informed me that we wanted to basically put on a workshop to go over some of the underlying procedures, not necessarily tied to a particular matter, but just sort of go through our operational mandates, our operational options with regard to the matters that come before us. And so that the topics that we're going to discuss, and these could be kind of all mixed together. We don't have to limit our discussion to the subdivision first and the zoning ordinance, etc. I think probably a better discussion. We're just going to talk about things as they come up. One of the first things that I wanted to cover with since there's so many that I have not spoken to about these matters before, has to do with open government compliance, the Texas Open Meetings Act in particular. Now, I don't know, some of you are newer appointees to the board, and I don't know if you've already gone through the Open Meetings Act training. Just kind of going down the list. Everybody on this side of the table gone through it?
Yes.
Video. Okay. Over here as well. Okay. So that gives you a nice overview of the obligations of public officials, whether they be elected or appointed, in general when it comes to discussing matters of public business. And as you remember from the video, all the matters that are before you as members of the board have to be discussed in an open meeting that's open to the public and for which advance notice has been given to the public. Recently underwent a major change. It's been 72 hours for many years now. It's gone to 3 business days. The city's already compliant with the new standard, but see language on the agenda that you're not familiar with, and they're not finding reference to the 72-hour rule because that's no longer how it's 3 businesses. But one of the things that arises out of that requirement to discuss things in posted and open meetings is one of the things I like to talk about are the inadvertent ways in which a member of the body might accidentally or unknowingly, or with good intentions, violate an openness requirement by having a discussion about public matters outside of the confines of a posted. There was this doctrine in the law that was talked about for a long time until the legislature changed the rule on it back in 2019. And that was what we used to call a walking quorum. That was a way that a member of a body could violate the openness requirement by having a conversation about public business with a group that was smaller than a quorum of the governing body, which normally the statute doesn't really care about. But then taking that discussion and successive small groups that don't approach or don't exceed the quorum threshold have that same discussion, so that by the end of it, you have this discussion taking place in separate conversations over the course of these several meetings of these smaller, less than quorum groups. That used to be called a walking quorum, and I think the phrase originated out of the seminal case on it, which dealt with the matter in the city of San Antonio, where there was an express intent to have a discussion with the full city council without having to meet in the city council, where small groups would walk into the city manager's office, have a discussion, walk out, then another small group would walk in. And so by the end of it, we had this walking quorum shifting between these small groups. Obviously, the intent there was to violate the law, and they were penalized accordingly. But concern for me as a municipal attorney are those instances where there is no intent to violate the law, and it happens sort of inadvertently, accidentally. Now, like I mentioned, that law has changed recently. It was declared unconstitutional by the Texas Supreme Court as being too vague to be enforceable. So the legislature took another crack at defining it, and the definition that it has come up with, I think, is a good one. I think should survive scrutiny. But a lot of my analysis, since that only happened recently, and I've been practicing for 20-something years, a lot of my analysis comes out of the really worrisome standard under the old law. And my advice really hasn't changed despite the change in the law to be less stringent or less worrisome. And there are certain procedures that I like to recommend to members of governing bodies, so as not to fall into a situation where you're inadvertently running afoul of the walking quorum or the walking quorum prohibition. The technology has changed since the advent of the old law in a way that makes walking quorum situations more likely, and I'm talking about email and texting. And so some of you may have heard from me in the past or heard from other municipal attorneys that you want to avoid communication with each other over email or text, because those kinds of communications count for the purpose of whether or not you have members of the body communicating with each other. Texted or email conversation is just the same as a verbal conversation. And because of the ease with which you can send that message to eventually a quorum of the body, sometimes inadvertently, in a word-for-word fashion from the original conversation, it's particularly worrisome, because you can basically include a lot of people in the same conversation that only took place between two members or less than a quorum of the body by simply hitting reply all or text all. And so you may have heard other attorneys, again, heard me talk about the practice of in your communication with city officials or with me or as an attorney to not include a bunch of other members of the board on the copy line or receive like a blast email from administration about an upcoming meeting, not to hit reply all. And internally, we also do some things to hedge against that, like line copying the people involved so that you don't accidentally hit reply all. Yes.
I'm sorry to interrupt, but I got to ask before I forget. You said to avoid speaking to one another. Right? You didn't qualify that as speaking of town business.
Right.
We are a small town.
Exactly. So the law only covers town business that is germane to the town.
The next thing is it only things that cover the boards that we serve on? In other words, can we discuss our views or our ideas that are only being presented council, for instance.
Yes, that's not prohibited either. You're a constituent of the town council. You have the ability to talk to each and every one of them. They're prohibited from talking to each other about what you talk to them about.
But we can talk to each other about our, our concerns for the town.
For the town.
That don't impact.
That aren't germane to a matter that
To our
that's on the agenda. And there are other exceptions too. It's not a complete gag order on any kind of conversation at all. There are even certain things that you can talk about that are related to the business of your board that are not legally prohibited. For example, you can communicate with each other about the placement of an item to be on a future agenda. In fact, I know with regard to the town council, it's necessary that at least two members of the town council talk to each other about an agenda item, because it takes two council members to mandate that the administration put on an agenda item. So if you wanted to talk to another member about wanting to see some matter on the upcoming agenda, you can do that. Even if that conversation ended up happening between a quorum, and let's say you approach one person and the person you talk to doesn't like the idea that I don't want to be on the agenda, so you go to someone else and ask them the same question. That's not covered. In fact, there's a specific case. I think this case was one of the things that led to the change in law that said that it's not a violation if the only conversation that's taking place is a discussion about putting an item on a future agenda to be acted on. But I still recommend caution when it comes to apply all texting. I know that in this meeting, for this meeting in particular, I fielded a question or two from council members, and it looked like there were a bunch of people on the copy line. I didn't see whether each name was a fellow member of the board, but if that was the case, that's something that I definitely recommended. There was another email. It looked like one member of the board generated an invitation for a calendar, for the automated calendar feature of the email system to appear here at the meeting. That's something that I wouldn't recommend you do either. Not that it's an express violation, but it's too easy to hit reply and have inadvertent conversations back and forth because of that email chain. If calendar invites are something that the board members would like to see, we can certainly implement that at the administration level. That way, you're not just informed or advised about it, but also given the direct automatic plugin that allows you to put it back in the application.
I think that's what happened to me, was that the first email, it had a tag on it saying add to your calendar.
Oh, okay.
And I said yes, so I didn't have to put it in myself. But then as I edited it, because it was 6 o'clock, then it hit everybody. So I think we have to be, it wasn't an unconscious act on my part, because I just assumed it went on my calendar. So
No, and that's
an administrative thing that we need to be sure it doesn't go on everybody's calendar when one person says add to my calendar.
And that's kind of why, for years I have been stressing that there's a lot of inadvertent ways that kind of fall into inadvertent violation. Not that I think that something of that level would ever come to the level of interest of the prosecuting authority.
I don't think I'll go to jail.
But I always want to keep all my officials as much trouble as I can. In terms of the other exception, of course, and we've had an item on it already. The open forum, that's not guiding anyone.
Your discussion just brought a question to my mind. In this case, the two boards basically have a majority of the same people.
Yes.
Okay, so if one board meets and we close the meeting, that's required by law, right? Etc. Or since it's the same 4 board members of both boards, would we have to post the meeting all the time for both boards? Because then they got a majority, even though it might be the same people, but they got a majority on this other board discussing issues that could pertain to the other one. And the question is, do we have to post for both at the same time?
I don't believe we have to, and that's because, and this is going to relate to something we'll talk about here in just a minute, and it has to do with the difference in the scope of authority of each board. In other words, the discussion that you're having as a member of one board, while it might relate to something that may eventually come to the other board, or has come to the board, you're talking about it in a way that you're talking about it in a different capacity with a different range of authority, in a way that doesn't permit the influence the other, just that one meeting. Now, does that mean that someone, some interested person might not say, well, you have a quorum of one board, and just by virtue of you all meeting as a different board, and that meeting is posted. Yeah, that's a possibility, and that may be the basis for the city to want to say, well, maybe we don't need that kind of identity membership. But I don't have concerns necessarily about an item that is being discussed by, let's say, the P&Z, even though it might relate to something that might eventually come before BOA, because the P&Z's role is so different from that of the BOA, that you're not really discussing that matter. The other exception I was just going to mention briefly, the public open forum. You're familiar with the rule that says that you can't talk about anything that's not posted on the agenda during open forum. Members of the public can come in and talk about pretty much anything they want. It doesn't mean that the body that's hearing those public comments has committed a violation because they're listening to something that's not on the agenda. But you will sometimes hear practitioners like me talk about how you're not allowed to interact with it. And sometimes I've heard public officials repeat it back to me in a way that makes it sound like what they understood me to say, or some other municipal attorney to say, is that you're never allowed to respond to the comments made during public comments as a public official. That's not necessarily the rule. The rule is that the council is not permitted to talk about anything that's not on the agenda. And so a lot of times what the public wants to talk about in the forum is a matter that isn't on an agenda. Maybe it's something that they would like to see on the agenda, or some matter of concern that hasn't yet made it onto the agenda. And so in those circumstances, it's not permitted for the board to have, or the city council to have an extensive discussion with that member of the public over that matter, because it's not on the agenda. A lot of times that gets truncated to just don't respond to the public comments, which is a good practice, but not necessarily. And of course, the exception, as I mentioned, the board, whether it be city council or a subsidiary board, can always take action to say, okay, we're going to put that item we discussed on a future agenda, and that's okay. That's permitted. So that's just my kind of brief primer or refresher on open meetings issues. And if anybody has any other questions about that, I can stay on that topic for a little bit.
Not the chair. Planning zone.
Well, actually, that's one of the topics I'm going to
Trying to tell us how to
so let me
stay within the rules.
okay. Yeah, let me go on to that because I know that some folks were interested in the distinction between a workshop and other types of meetings. So under the Open Meetings Act, the legislature has never made any kind of distinction between a workshop and any other type of meeting. Workshop is a term that a lot of governmental entities use to signal to the public that there's only going to be a discussion and there's not going to be an action. But that doesn't have any basis in any particular law or statute or case. It's just a sort of a shorthand way of letting the public know this is the thing we're going to be talking about extensively, but we're not going to act on it. Now, if you could have something that's titled a workshop and then an agenda item that indicates that the body might take action, and that action would be entirely legal because workshop doesn't have any special legal meaning. I think the context we're using it in here tonight is the traditional context, which is we're going to have a discussion about these things. It's not going to result in any particular action on the subject matter. We're just going to be talking about it. But in the law, there is no distinction between a workshop or regular meeting or special meeting. Meeting is a meeting is a meeting under the open meetings. As long as you have a quorum of board sitting in the same room, public having access to it, and you're talking about the government's business, that's a meeting. Now, whether it's a legal meeting or not depends on whether you followed all the rules for posting and access to the public. So, any questions on that? Because that is a good question. I hear that question not just here in Laguna. I hear it boards that represent lay people are sometimes wondering whether there's a solution there. Any questions? All right.
I've got a comment of, so often we, as you say, lay people on boards that don't understand even the rules of whatever ordinances we have or the steps in the process of trying to pull together, like, say one of the people come in for a variance or they come in for a zoning change and they're going beyond that. They're saying, oh, we're going to do great construction. Look, that has nothing to do with board variance or planning and zoning. Right. But we're limited in discussing that.
No, because it's germane to the topic. In other words, when an applicant comes before the P&Z seeking a zoning change or a subdivision approval, or an appellant comes before the Board of Adjustments seeking to overturn the decision of the city official or to request advance permission to vary, to develop something that's at variance with the ordinance, a lot of times they'll be, all the time, they'll be required to support that request and convince you that it's a good idea. And so naturally, they're going to want to present information that they think will assist you in that decision or convince you that it's a good idea. So if someone wants to talk about, the great construction they're going to do, assuming that you give them the authority by approving the subdivision or granting the variance, that's germane to the topic before you because they're providing information to you in hopes of convincing you that you should vote in favor of what it is they're asking. It may not be exactly the information that you want to hear, and you may have questions beyond the best foot that they're putting forward. But it's germane to the topic, and it's certainly not out of bounds for them to raise those issues.
Sure.
Is it out of bounds for us to ask questions about those things if they don't present information?
Not at all. You've got the discretion as members of both bodies to make decision in a lot of cases, and in other cases you're mandated to make a decision based on certain things. And so if they haven't presented the information to you that you're mandated to act on, then it's certainly appropriate for you to request it. And if they don't provide it, it could be appropriate for you to deny it just on that basis. If it's a discretionary item and where the task at hand is for these applicants to convince you that you should vote in their favor, and you haven't been convinced because of the dearth of information that's come your way, you can ask for it. And if they are unable to provide it, that would be a basis then for you to, or that would inform you. But no, as long as it's on the agenda, then the discussion that is germane to that item is completely within the bounds of what you can talk about. Yeah. Any other questions on that?
We're not there.
To make sure I'm understanding correctly, when we're called in one board, we're serving out another. It's important to keep
I haven't seen anything.
conversation
To tell me what you're
remain to and within the scope of authority of the board we're on.
Yes, and
But
that's
not to discuss how it could then be talked about in the other one.
well. The discussion is probably going to be inevitable, but what you want to stay away from is making a decision that really belongs to your other capacity.
Or effectively trying to lobby for a decision that affects the other capacity.
And I'm going to talk about that under item C, about the different roles, the different authority, different jurisdiction that each body has. They do both cover the area of land use regulation in the municipality, but they have very different jurisdictional boundaries and different outcomes being sought. And so I'm going to cover that in item C. Let me go over the items that we have here, A and B. I'm going to take them together. I know that these two things exist under two different number of ordinances of the city, but what I want to get across, and this is from me, I've represented the town since 2018, and gone through periods where there has been virtually no activity under either of these ordinances. In fact, I'm certain that there's never been a request for a zoning change since I've been in the town, and very few requests to approve new subdivisions since I've been in the town. So these are two areas where these ordinances haven't seen a lot of action. But when they do see action, municipal attorney, reading through them, I can say that they need some work. There's things there that I don't know exactly, you know, what the process was to assemble them or put them together back when they were approved in 2014 and 2017. But it looks like there were maybe some attempt to utilize kind of off the shelf language that may have been appropriate for a jurisdiction not Laguna Vista, but when translated in here to Laguna Vista, it didn't quite make sense or didn't quite fit. There are some zoning areas that are identified and discussed in the zoning ordinance, but not identified on the zoning map. There's just a lot of little things. Now this relates to a problem that we're going to fix in administration through either directly or through the use of some of the other projects that we've got going on. Namely,
As far as the ordinance?
Yeah, that's what,
Yes, essentially, the city has a grant approved from the General Land Office, GLO, and it is to do a comprehensive plan or actually expand on the existing one. And in doing that, the subdivision ordinance and zoning ordinances have to be reviewed and updated to make sure it's in compliance with federal law and state law, et cetera. And at the same time, getting the input from you, the board members, of boards that ordinance is clear, understandable, and that can be enforced. So basically, the way the ordinance is right now, as Mr. Osuna is explaining, it really needs a complete revamp. Revamp.
and so now that being said, it is still the law of the land here at Laguna Vista, and it still has some definite requirements in it that are clear, that can be applied on the ground when it comes to people who are asking for subdivisions or zoning changes or variances. And so, I don't want to give anybody the impression that it's completely useless and we can't rely on it. It does have strictures and mandates that everybody is on notice of, whether they've read the ordinance or not. So it just depends on what it is that they're asking the town boards to do when they come before us, and then administration or me as council will then advise you what can be applied, what can't be applied, what can't be enforced. I know that back when we started seeing a lot of activity with regard to the subdivision ordinance, I had that discussion with the members of this board at the time. What parts would apply, what parts couldn't, and we eventually approved that. But it's not without faults, and it's going to be cleaned up. We're going to make a concerted effort to do that, and it's going to be done with the input of each. That's true for the subdivision ordinance, which is a little better written than the zoning ordinance. The zoning ordinance, because it's a bigger document, has more inconsistencies in it. And then also they're old enough that even without those problems, they probably would do for review anyway. Zoning ordinance is 11 years old at this point, so that's due. That reason alone means it's due for review. I mean, I don't have really much more to say about them. And I'm certainly happy to answer any questions about them. But just suffice to say that they're under review. They're going to be changed, but they are the law of the land. They're still enforceable and applicable. And we just need to take it on a case by case basis.
And you're going to be making a recommendation.
Yes, depending on who we get to do the nuts and bolts of it, whether it's me directly or through one of these grant approved processes, I will have the final review of it before I recommend to the town council that it be approved.
And with that said, if I may, we provided you with copies of the subdivision orders and the zoning.
That's a reminder.
I'm sorry.
Yes, that was.
Yeah, both of them were in there, including the handbook. But certainly those two ordinances, please take the time to begin going through it and scratching and adding comments, things like that, because we are going to need that input as we update both ordinances. We certainly need your input, especially in the positions that you hold. So you have that, and so we hope that find it useful, provide us with your comments.
Let me ask you this, how's this process gonna work? Is it you feed us everything, or we pull this together as a whole?
Well, I think that certainly if you already have in mind something that has troubled you about the ordinance, definitely bring that to the attention of administration. And we'll flag it as something that needs particular attention in terms of revision. I don't know that it would be as helpful if I just kind of pointed out all the problems and then gave you a list of, because some of them are purely legal issues and it's something that might never come before you as a member of the board. So you'd be looking at a lot of stuff that may not have all that much importance. But yeah, definitely if there's something about either ordinance that you've looked at and you've already made the determination, this isn't making sense or this isn't right, this should be different. Definitely bring that to our attention. We'll flag it for particular attention. The rest of it will be, again, if it's something that some outside vendor is going to do the legwork in terms of recommending a revised ordinance, then it'll be that entity, and if not, it'll be me. So, but either way, I'm going to be the one that kind of looks at it and says, yes, this is one that will pass muster in any kind of challenge to our authority to regulate land use, and I recommend this to the town council before the town council.
I mean, I would suggest that we all have some kind of input in this. If we've got notes that we want to put in here, and things we'd like to see add.
Absolutely.
I mean, for the last 2 years I've been on the boards, I said we need to rewrite these. Ventures brought this to the forefront. Approach and get it, hopefully get it done. But like in some sense of the word, as residents, we'd like to have a good piece of the input. Sure, we all have something to say about it. One of our big things is water retention, and I brought that up time and time again. Complimented that on the 50-acre parcel. After I actually should have got a way to redesign it, he said, "Yes, I'll put it in water retention, even though it's not in your ordinance." So we were complimented by that, and we'd like to see similar things happen the next go around. So that's sort of whenever, as an architect, anytime I work on or a planner, I work on subdivisions and planned unit developments. It was if you did something or you wanted something outside of the variance or outside of the zoning ordinance, you came back with something you're going to help the city with or help that development improve so it looks it becomes a better development. And I wasn't seeing that in the presentations. So that's part of the reason for the thought process. Yeah, I think everybody here would have some good input, or else it would be a plan that would not be on this board. So yeah, we'd like to move on across the region.
I'd also like to have the fire marshal or person be in this also, because a lot of my questions on this subdivision that we're looking at is a lot of the fire access to it, radius turning for fire trucks, sprinkler system, because there's so many units together.
Yeah.
We need his input too. Are you going to take that responsibility as a fire marshal?
Well, so let me ask you about your observations there. Is it a situation where you're observing deficiencies in the ordinance or the ordinance adequately?
Well, the fire sprinkler is definitely an ordinance. The turning, ordinance, whatever, but let's use some common sense about turning radiuses and fire trucks, accessibility for fire. The building's so long, I'd like to see a little separation where they could get between that long stretch of buildings and go to the backyards, which is really inaccessible.
And I think what Terry's trying to voice is we're concerned we're getting pigeonholed.
Okay.
Although we do in our particular variance or our particular portion of it, and we have a city engineer, we have a city building inspector, and those would address those specific issues. But if these developers come in and say, oh, grant us all these variances and we'll be great. And we look at it and say, no, you're not great, because we haven't heard from the inspectors or engineer as to these specific items that we know, or I know, are not gonna pass.
Well,
See,
let me start with the ordinance itself. So.
do you want to say something? If I may?
Yes, if I may. So the development cannot begin unless it's approved by a fire marshal. Fire marshal has to have the plan and go through it first.
Correct.
You know, if he says, no, this is not gonna work, this is not gonna work, this is not gonna work, you know, it won't. And fire marshals, as you know, as what you're saying right now, he's gonna look at every single thing. He's gonna look at the sprinkler system, he's gonna look at the turning radius, he's gonna look at the entire. So it's, you know, so what we've been going over here the past couple of months is nothing set in stone. We're just trying to get the ball, you know, rolling,
Right.
basically.
And again, that's one of the items that we need to address for the ordinance, because, and beyond that, we don't have a fire marshal in Laguna Vista, am I correct?
You're correct, and see, that's why it's important that we get a clear question or concern from the board in reference to that, because we don't have a fire marshal. We have to go to the Cameron County to get that fire marshal to do what I call the payment for us. And sorry, and now by the same token, which we can't present to you officially, but I can tell you that when staff has gotten together, including our fire chief, who cannot speak to this officially,
Right.
but however, he knows because he is a fire marshal,
Yeah.
but he's not the official fire marshal for the city.
Totally respect your opinion.
Exactly, that's where I'm going.
Right.
But he cannot come and present to you his opinion as a fire marshal because he's not that representative of the city. However, in talking over here as staff, we have presented those things to him and he has no problem. He's seen it. And he says, yeah, it could be better, but there's nothing there that we can say from the fire department, fire marshal, this is wrong. This is going to be a problem. But at the same time, we're discussing it, yes, but he can't say it until we officially were just submitting him as a fire marshal of Laguna Vista. And to go to Cameron County, and we tried, but we were in the long list in terms of everything. So
What about Padre Island?
the same thing, you know, and some of these people really don't want to get involved because it can lead to other issues when they don't have the responsibility to this city.
Well, and it sounds to me like if we're gonna ask the county or another city for their fire marshal to help us, it's gotta go through city council and it's gotta go through their council.
No, it always has to go through county, period. It always has to go through county because they are, the Cameron County fire marshal is our fire marshal for Laguna
Oh, he's
Vista.
already signed.
He's already assigned.
Okay.
He's who, when we open Dollar General, anything we do across the street, everything has to go through him.
Is that because of the population?
Yes.
And I don't know who to address, so I'm just gonna speak this question. If indeed there were found to be an issue after the Board of Adjustment met and agreed, and then there was an issue which changed the plans, would those plans then come back to us?
It'll come back. It'll go, yes, they should. But for the most part, any plans have to go through him. Any changes have to go through him. Anything final has to go through him. So he's throughout the whole entire process, he's there. He has to say it's okay.
And we're kind of going back into the item that's going to be next, go beyond the workshop, but essentially that's what staff and the engineer, we were looking for, that there were specific requests for variances. And that's where we as the people responsible for this, we needed to know from the board on each item, on each request, what is the concern with that one? far as you're concerned with number 3, number 4, number 5. Once we have that, then we go to the next process, the next step, which is sending it through the fire marshal. It's not only that, we gotta put it, even though the developers have the responsibility of going to Laguna Madre for water and sewer and utilities, we as the staff, we need to also put that information to them and not just rely on them to rubber stamp it or anything like that. We need to sit down with them, but we need to know exactly what we know, but the concerns that you have to be specific in terms of those variances that are being requested so that we can deal directly with that. But when we don't have that, then we're at a loss. We can't provide anything in writing to the developers or the fire marshal per se, because we don't know exactly what the issue is with each particular variance request. And that's what we need from the Board of Adjustments Board. Where you say, request number 1, yes or no, or this is what we would like to see. Request number 2, the same thing all the way through 5. That way, then we take it through the next process and get everybody involved that has to be involved and check off. And then we come back to you and we tell you this is what we found.
A couple of concerns I would have is, and there are several people from my understanding, like myself, who have significant experience in municipal government outside of Laguna Vista because we may have moved here. And so we tend to have knowledge of this would be an issue, this would be an issue, this would be an issue. But what we would probably need is clear guidance on what would be overreach for our particular board. This needs to stay within this realm. And then the other is, and probably a greater concern for me, is the premise that we would like to see something being spoken for the board without the board voting that that's what we want to see. And I think that it holds a lot more weight when we actually take a vote on, a motion that, the board would prefer that this developer show us this or this and have an actual vote. It carries a lot more weight than if we communicate in a more casual manner what we'd like to see and nobody opposes.
And we hope the staff and the city engineers here that even you go to the next item, which is then a Board of Adjustments item for action, then you provided just that with a vote on each of the items and basically with the concerns as to why you voted for it or against it or what you would like to see different.
But it's not a matter of what I or any other board member, it's
the board.
We as an entity.
Exactly.
As a forum, or as a city.
Yeah, because the thing is that all of us have opinions, but we can't base it on somebody's opinion. We have to base it on what the board has discussed and basically has told instruct engineer, the city manager, our employee doing this work to say, we don't want this because of this and this, but this is all right, or we would like we could consider it if they change this to this.
But such an instruction has to come
Exactly.
from the whole.
Yeah, as
And
a
the whole is determined by a vote.
and with a vote.
Right, and then they'll develop the plans to what was agreed on, if there was any variances that were given, then they will take those plans after they've been completed with the variances, if they were approved or not, and they'll take that to the fire marshal, and the fire marshal will then look it over and say, this is not gonna work, that's gonna work, this is gonna work. And then if he doesn't approve it, it's like, we can't do anything, we can't break the ground, we can't.
And would similar be the case with the water district?
Yes.
Yes,
Because the water district can kill, we use that word, but if their system cannot provide the flow of water that they need or the ability to take the wastewater and treat it appropriately with their infrastructure, they're going to say, we can't do it at this point. It's going to take us 5 years for we to get there. That development is dead because they're not going to have those utilities. And no matter, even if all of us wanted the development, it's not going to happen. See, it's a tedious process and it involves a lot of people with checks and balances. But we are the ones that need to start off with the specific questions, the specific concerns, so that we can go and sometimes we have the answers ourselves. And we can tell you right away, that we can do, or no, that we cannot. And of course, in some cases, we might need the attorney's opinion, legal opinion. But that's the thing that the board needs to verbalize these things and make it part of the record of them, and a vote would make it obviously perfect. But when there's no clear discussion or directive of saying, this is the problem with this request, this is the problem with this second request, then we can't move. We can't move until we get that direction from you.
And of course, it is possible that, you know, a third of the board has problem A, a third of the board has problem B, and the other third has no problem whatsoever, and it creates not a consensus for what the issue is. But 2/3 of the board have an issue.
Oh, yeah. And that's, but when there's a vote on the full board, but there wasn't a clear discussion with a clear instruction, then again, we can't do anything.
Yeah, I knew, for instance, talking about the water itself, many people in town concerned about, oh, we end up with water rationing in a hot summer when there's no rain. So how in the world can they tell us they're gonna have enough water until they get a desal plant or whatever they do, which is how many years, 5 years from now? We get the water. An example, there were 9 different subdivisions that were proposed in Hill Country that were all rejected. They don't have enough water. Aquifers are running dry. They don't have enough water, and which totally threw me because I'm reading the article, and 2 of the guys are suing. Wait a minute! Don't sue. Come back to your board, or come back to the city, whatever it is, municipality, and figure out. Let's spend that money on figure a way to get more water. What are you suing for? We're not going to get it for it. So that's the other side of that same coin. In some sense, we're worried about the legal aspect, of course. At the same time, too, we need to be logical and it makes sense. So that's what catches me off guard.
Well, that's a good observation. It goes back to something you said a little earlier about being pigeonholed by the ordinance. That's a very valid concern because, you know, land use regulators like municipalities are pigeonholed. We're limited to applying what we've got in this is Texas, and we value our property rights, and the way that the legislature has translated that into the laws that affect our ability to regulate land use is that it puts an enormous burden on the municipality and any government that wants to engage in land use regulation to justify and substantiate the restrictions and burdens that we're placing on private land. It's a time-sensitive process. It's substantive. There's a lot of substantive review that goes into it in terms of what we regulate, what the town council chooses to regulate. And if anything goes wrong in that process, generally that's held against us as the tenant, and the landowner is then permitted to do what he wants. And so that then feeds into the answer to the question: why sue? Because they know that they're going to get a favorable ruling likely in court, unless the process that the city applied was tight, and the language that the city is relying on for the regulation was also tight. What we were talking about in terms of fire marshals, that has a couple of stages. There's a fire marshal review that can take place before you grant your approval, and then there's another review that takes place. And I think this is probably more what you were talking about, Doobie, in terms of pre-construction review that has to take place. So by the time it gets to Doobie stage and to the fire marshal stage, when they're doing that level of it, it's out of your hands. You will either have approved it or not. Right. But there is a role for you in terms of approving the subdivision to involve the fire marshal, engineer, or building official to look at what's proposed before you say, yes, this can go forward, assuming you build it as you propose it. But the ordinance has to provide the ability to do that. And if it doesn't, we're on shaky ground in terms is our ability to mandate. And so, that's obviously one of the things that we're going to be looking at in terms of the revisions to the ordinance to ensure that all the things you mentioned, things like the ability to turn a fire truck around, to supply water to a fire, are in the set of requirements that you can impose on a land user and proposed developer, or tell that the developer, no, you haven't adequately addressed these things in section X of the ordinance, and therefore we're going to reject your request. That's a good kind of segue into the roles of P&Z versus DOA. Generally, well, not generally, this is the case. Like I said, you have the same. You're looking at the same area of law, land use regulations, but you have very different set of rules and set of jurisdictional reach. I'll start with the P&Z because that's generally where it starts in terms of land use regulations. So the P&Z has the ability to grant subdivision requests and subdivided piece of land, which is a legal requirement on most land conveyances and most land development in Texas, especially within the corporate limits of the municipality. Now, the P&Z does not set the ordinance. That has to be done by the town council. The town council hands you the document, and then that's the document that you as P&Z members apply in the face of a request for subdivision or for a rezoning. You get the first crack at deciding whether or not the requester has made a sufficient request. And the term I use there is original jurisdiction. You have the original jurisdiction to decide whether or not a subdivision can be approved or not, or whether a zoning change can be made or not. There are some procedures that get applied, again, have to be in the ordinance in terms of who's entitled to notification of the proposed change, and, what kind of things those users have to do. But again, these are things that have to be within the ordinance in order to be enforced. And so, in your role, in your capacity as a member of the Planning and Zoning Commission, that's your jurisdiction, an original jurisdiction to make these substantive decisions about whether or not someone gets to have the subdivision requested or the zoning change requested. And in the statute, you'll see that there are processes that you got to apply, just like the town council. Sometimes you've got to hold public hearings, and then you get to vote on it. That vote then gets reviewed by the town council, and so that's going to cover all of most of the things that come before you, where someone is asking for something substantive in the town, a new zoning category for an area of the town, a new subdivision. You're bound by what the ordinance allows you to impose. In other words, if the ordinance sets forth requirements and the application you get demonstrates that those requirements have not been met, then you have the ability to deny it, the ability to say no. But the law, it gives you basically three things you can answer whenever you're presented with this proposed land use that you're going to regulate. You can approve it, you can deny it, or you can approve it with conditions. Those are three things that the statute says in the P&Z. So obviously, an approval is just the plan gets approved as presented. Denial is just gets denied and doesn't go any further unless the user proposes something different. Approval with conditions, which I want to say, just in my work with other communities, that's the majority of types of approvals that come out of P&Z, is where you tell the land user or the developer, we're not going to approve this as you presented it, but if you change the following things, we will approve it on the condition that those things get changed. That a certain line gets drawn in a different place, or that certain other infrastructure gets imposed. Where you want to be careful there is, again, in making sure you apply what the ordinance allows you to apply. And then there's another concern, even when you're applying what is directly written in the ordinance, although it's more a concern for the town council, not so much for the P&Z. But it is possible for the town council to impose a regulation that is overly broad or requires more of a developer than the law allows us to. There's a whole set of cases and a whole set of jurisprudence dedicated to those principles. Really important cases coming out of the Texas Supreme Court, and the U.S. Supreme Court, because these issues are analyzed under the constitutional taking clause. In other words, the way the courts look at this is if a city imposes regulations on land use that diminishes the expectation, the reasonable expectation that the owner of the land had for the development of that property, then the city has engaged in what's called taking. Familiar with the idea of the Fifth Amendment of the U.S. Constitution that the government can't take property unless it adequately compensates the person for whom the property was taken. The same doctrine applies in the text under the Texas Constitution. I cannot remember the exact article and section because we have a much bigger constitution than the U.S. government has, believe it or not. Yeah, with a lot more numbers, a lot more sections. But the principle is the same. The government cannot take property without compensation. And so the way that applies to land use regulation is that the government can only impose a reasonable regulation that is commensurate with the impact that the proposed development has on the community. If the city government goes beyond that, then it runs the risk that it has exceeded its constitutional authority and has actually taken some value from the property that it was not allowed to take and must compensate for the land. Now, we're a long way from that happening here, even with the efficiencies that we have. But it's something that my review is it's going to involve my having to review whatever does get proposed as a final ordinance to ensure that it stays within the constitutional limits. Now, as applied to you as P&Z members, your obligation to the Constitution is to apply what's in the written ordinance and not to improve it. And that's why your input ahead of development of the ordinance is going to be very important, because once that ordinance is set in stone and approved, then you're limited to what's within the four corners of the document. Whatever you think might be a good idea or might be essential, if it's not contained in that ordinance, we're on shaky ground to try to. But that's basically the extent of authority of the P&Z. Like I say, regional jurisdiction to make substantive decisions about new developments, so categorical zoning changes. Any questions about?
As an example, and clearly we need a better language for a PUD, planned unit development, because even in planned unit development, there's a separation of retail from residential. And
You're talking about tradition.
yeah, tradition. You walk in the door, you've got a separation between retail, because any not only on a governing standpoint or ordinance standpoint, but on the developer standpoint, you just want the residents of the HOA telling the retailer how to run his business, or vice versa. So there should be a clear separation of that. I don't know if it has to be an ordinance or it has to be just in common sense. So where do you take that?
Well, so it's a little bit of gray area because the zoning that applies throughout the town tells anybody who picks up the ordinance, reads it, what kind of things can take place, what kind of activity can take place in a particular zone, commercial, residential, some kind of mixed use, industrial, agricultural. Those are the things that the zones dictate within the town. So the PUD operates a little differently. It by its nature allows a little more flexibility and almost permits the creation of mini zones within a zone. But now, if we want whatever provision we have for PUDs in the ultimate ordinance to include that kind of separation, it's got to be specified. Under the statute purposely does not say a whole lot about it because it leaves it up to the community to decide what kind of things they're going to permit, what kind of mixing or different categories of usage they're going to allow to be close together within the bounds of the PUD. And so if we want, if the political decision that the town council is going to make in that regard, is going to dictate what PUDs can look like, whether those kinds of separation are going to be required or not, and that's a function of the town council's decision making. And then when it comes to you as a member of the P&Z, that it has an application before you for the approval of the PUD, that's going to be what you apply, coming out of what the town council decides. But it's that's the same process as I described earlier for applying your regular non-PUD subdivisions and so it's got to be. The ordinance is vital in that regard. You can only do what it says. So, but again, this is where your input is going to be important, because we haven't had a lot of that kind of specialized request. We've had some subdivision requests, of course. Most people know that process and what's involved there. PUD is a little different. It's kind of a hybrid process, and the statute, by its nature, leaves it up to the community to decide. So let me move on to the Board of Adjustments. So the Board of Adjustments, again, deals with land use regulations, but from a different perspective. And in representing local governments, we use this terminology, or this rubric of hats a lot when we're talking about the capacity in which you might serve, especially where you serve in multiple capacities within the town. Having membership on two boards isn't the only time that occurs. It occurs very frequently within city administration itself. It occurs within my office as town attorney. Sometimes I've got to put one hat on and take it off and put a different hat on in different circumstances, depending on the kind of advice I'm bringing. But it's very important when it comes to the distinction between the Planning and Zoning Commission and the Zoning Board of Adjustments. So in that capacity, when you're wearing your BOA hat, you don't have original jurisdiction of substantive changes like that. You have instead what's called appellate jurisdiction, sometimes quasi-judicial jurisdiction, where you're sitting in review of a decision that has been made by a public or by a town official, a building official, or a fire marshal in rejecting a permit or rejecting a certificate of occupation license. Yeah. So those kinds of things are decisions that are made originally by building officials, and someone who is aggrieved by that decision can have that decision be reviewed by the Board of Adjustments. That's the role of the Board of Adjustments, to sit as a kind of sort of mini court in review of a decision that has been made by a building official. The other thing that they could do is render a decision in advance over not the decision of the building official, but over whether or not there's going to be permitted some kind of variance in the strictures of the ordinance. Those kinds of variance requests don't involve you reviewing and potentially overturning the decision of the building official. Instead, the person who comes to you with the application knows in advance that what he's proposing is contrary to the mandates of the ordinance. But he or she is asking for permission to vary those requirements in some way. And so the BOA has the jurisdiction to review those requests and then decide whether or not it's going to permit some modification to the exact requirements of an ordinance. And that's typically there is sometimes a combination of variance request process into what the P&Z does when the P&Z is going to, say, for example, approve a subdivision and the subdivider is asking for a variance within that process. P&Z has some jurisdiction to grant that as part of the approval of the subdivision, in which case there's not any need for it to go before the BOA. But the vast majority of cases where the BOA is making a variance decision, it's going to be somebody initiating a request to permit some kind of non-conforming proposed use to then get permission for that from the US BOA. So again, you don't, as the BOA member, just like the P&Z, you don't have the political authority to determine what those things are, what those requirements are in the ordinance. Only the town council can do that, but you do have the ability to move a setback line, permit a structure in an area where the ordinance might not otherwise permit it. And there are a number of factors that you're required to look at when making that decision. It's not just a complete thing to say, I'm going to throw the ordinance out the window. There are some factors that guide those decisions. Generally, those factors fall along the lines of your ability to grant permission to do something that isn't going to fundamentally change the character or the nature of what's already in a particular. In other words, you might be more inclined to grant a variance to move a setback line a couple of feet in a neighborhood where everybody else has already violated the setback line, or built in excess of the setback lines. I don't know if you run across this notion of a non-conforming use yet. Non-conforming use is a legal term of art that that describes a condition of some property use that is in violation of an ordinance, or is not according to an ordinance, but that the city doesn't really have any ability to correct because it's been in place for a long time, it's grandfathered, something along, or there's been some special permission granted. And so you have these sort of construction realities out there where people aren't following ordinances, and it may be that that's okay because those uses are considered non-economic because of their age, because they were in place before the ordinance got changed to prohibit that kind of thing. And so in situations where you have a lot of non-conforming uses in the neighborhood, and someone who is not able to take advantage of that non-conforming use wants to request a variance to bring it in line with the way the non-conforming uses exist, that's something that you can consider as being worthy of a variance, because it's basically you're not changing anything, you're just bringing it into line with what's already out. Those kinds. Generally, even though there's no specific language or specific threshold in either the statute or our ordinance concerning variances, generally we're talking about things that are minor, things that are not considered substantive. The thing asking to be varied is measured in feet. We're talking about a variance that is going to measure inches, or a very small number of feet compared with the number of feet that are contained in that regulation. If we're talking about building height, let's say a maximum of 20 feet, then the variance, the proper subject of variance wouldn't be an additional 20 feet. It would be something like 21 feet or 22 feet. That's generally the rules. Again, there's no place where you can find what those thresholds are in the law. A lot of it is just kind of handled by feel, but the gist of it, the essence of it is that you're permitting at most something that is only going to slightly change what is required. In cases where applying the strict requirements of the ordinance would work some kind of undue hardship on the applicant. Again, you won't find those rules written anywhere either. It's very subjective. You kind of have to work through it every day. Different. But those are generally the types of things that DOA will consider when deciding whether or not somebody's going to get permission to step outside the bounds of the ordinance.
Now, in that statement, it sounds as though we're leaning to the developer. And if there is a condition that he's trying to address, then it imposes a problem on their neighbor or on the city itself, where does that fall in?
Well, it falls in all steps of the process, because creating problems for one's neighbor is going to first be addressed by the zoning ordinance, or by the zoning and subdivision ordinance itself. In other words, that's something that the town council will first be addressing in the ordinance by mandating that with all its rules, all the rules that are contained in the subdivision, that basically the underlying idea is that we're not harming the neighbor, not doing something that's going to disadvantage neighbor. And then of course that review continues through the approval process and through the post-approval process and the pre-construction process, where all these things will be looked at by various town officials to ensure that no one is going to disadvantage a neighboring or adjacent property. But it's also one of the factors that you consider when presented with a request for a variance or an appeal of a building official's decision. In other words, you can look at the situation saying, yes, I understand that the variance you're requesting is very minor in nature, but if we allow this, it's going to create the following problems for your neighbor, for the adjacent landowner, and therefore we're going to deny it on that basis. As long as your decision on that is reasoned, and reasoned in a way that Mr. Trevino described, where it's something that the administration can then put into a document and say, your rejection is for the following reasons, then you have a lot of discretion as DOA members. Again, you have a quasi judicial role, and those decisions are given a lot of deference in the law. Not unlimited, but a lot of deference. So that's the role for the effects that a variance request or an appeal might have on one's neighbor. It's considered at every stage of the process. Basically. Any other questions about the role of DOA?
Another question. So can a variance be made with conditions as well? Am I
Yes.
hearing?
Yes, in other words, you might, in response to a variance for a structure height, the person asks for 5 feet, you might say, well, we're gonna deny 5 feet, but grant you 3 feet or 2 feet. Or we'll grant you the ability to do that, provided that you rectify some other condition of the property or mitigate the impact that your change is gonna have on some other aspect of the property or the nature.
I have a question. Regarding the boards, here in the handbook, it says the chair voting privileges. The chair is not entitled to make a motion or second or to vote except to break a tie. Is this true?
Yes, that's a kind of parliamentary procedure feature that is pretty common among well, the city governments, the governments of subsidiary boards like the P&Z. Those are rules that the body itself is permitted to make. The statute doesn't cover it, and so if the body wants to have it set up to where the chairman is just a presiding officer, not a voting member, not one who is scheduled to make the motion, we can certainly do that, and we have that provision there. Notice though that the town council operates differently.
Right.
With the presiding officer of the town council that has a vote. But so that was probably put in there because that's kind of a more common situation.
So we don't need to follow this. That way it's not it's in there.
Well, no, I'm saying that you do need to follow it. In other words,
So the chairman cannot make a motion or a second.
a motion made or a vote taken by the chairman runs the, since we have that rule, runs the risk of affecting how firm the action is. You know?
Right.
A lot of times, there's a lot of ways around it. If the chairman says, well, I think we should do X, yeah, do I hear a vote? Yeah. So in other words, if the chairman looks like he really wants to make a motion and no, he can't, but someone else also thinks it's a good idea, they can enter that motion for that.
I understand. I just want to make that clear.
Yeah. And again, that's an internal policy that we developed. We probably have the jurisdiction to change, although you're looking at the
Advisory board.
advisory board policy developed by the town council.
Right.
So the town council could, if you wanted to, change that rule. But it also helps to make sure that minus the chairperson, you have an odd number of members so that you're not faced with time. Now, ties are not the end of the world when it comes to voting. In fact, I know that I hear a lot from public officials that are worried about ties. Ties are basically no's whenever it comes to something that needs to be affirmatively approved by a majority of the body. So let's say you are in a situation where you only have 4 voting members present at a meeting, and you have 2 votes for and 2 votes against. Well, that means that it's against because you need a majority to approve most things in city government. So you need 3 to.
Flip side, I don't think anybody wants to be chair.
Yeah, it's that you in exchange for giving up that power, you get the awesome authority to preside over the bang the gavel.
Wow.
Any other questions about the distinction between the service on various boards, the development of the laws that govern us? Any questions? Anything else?
It's up to the chairperson now, the Board of Adjustments, if they want to go to the next item.
Okay. And in fact, the P&Z has no further items. The P&Z can technically adjourn it if you wish.
Yes, and the only thing is that if the board, the chairperson moves to go on to the next item, and we have the city official, building official, we have the city engineer, and of course ourselves, and of course our attorney, that can answer your questions in reference to each of the variances being requested. Because that's what we need to follow in the document, so that we can communicate that to the developers. But it doesn't necessarily have to be item by item, but each item has to have a reason why you rejected it, or well, you approve it, or you can approve it with condition. So, for example, the ordinance requires a 15-foot setback in the back of the property, the units. They're asking for 8 feet. They want you to waive 7 feet. Now, you can approve that, or you can say, no, we'll approve with condition that we'll only give you 3 feet or whatever. Or no, we just reject it. But then we can communicate that very specifically directly back to the developer. And then it's up to the developer what they want to do after that.
That's what we tried to do. That's what we did, essentially.
And there are 5, and I know that everybody has seen them, but there are 5 variances, the requests.
Yeah.
We can take them one at a time.
Actually, I got 4.
That's not
The engineer,
that's not the,
yeah, but that gives me something to look at. I didn't really see anything.
this is on the ordinances.
One of them is obviously the setback, which they're asking for basically 50% reduction.
Well, addressing that one, I didn't like it because normally it's a 5 foot on the sides, that's 10 foot for fire people to get through and work their fires. And I wouldn't like to see 8, I'd see maybe 10 foot at a minimum. Just to give access.
Do we need to adjourn the P&T meeting before we discuss the BOA? Or is it?
We don't, I'm just saying you can, like, if someone here is on the PNC and not on the BOA,
Well,
they're
both meetings
Just
are open,
come back.
right? Both meetings are open, and the things we really need to address is the zoning, or the not the planning and zoning, but the variances. Because the variances is where the,
correct, but that's only a BOA matter, so the PNC is basically concluded its business, it can adjourn. And anyone who's here only for the PNC is free to go home.
well, before we do that, I'd like to at least at some point, when do we start this development of our ordinances? Planning and zoning and the board of variance.
So that's something that we're,
What's the time frame?
working on.
I'm sorry.
Go ahead. When do we start redeveloping the ordinances for planning and zoning and for just the city essentially, and for the codes and so on that we're talking about?
The thing is that we are going to use that grant, but that we have to follow that procedure, which right now, if I could tell you, we could start next month, but I'm not sure, because there's a bunch of other issues in starting that grant that really, we're not ready to do this.
Okay.
But it seems it would be best for the town if we began to read them over, look them over, and make suggestions.
Yes.
And we would make those directly to you, or
I think we take it to the city.
Will the city council be the one to
Well,
set
what
the bill and recommend?
what he's saying is this, we need to go through the process. And if you will, the process is for any of us, as he stated to begin with, can't talk to each other, but we can send our notes to the city manager and request that he
What's going
include
to happen
those.
there pretty early is that, yes, well, but what's going to happen is obviously the city engineer, the city building official, myself, staff, will go through the ordinance first and get those things, the ones that are real easy to say, this is bad or this is good.
Yeah.
But then at the same time, we want to get your input and put that together. And before we even present it to the town council, it still has to go to the city attorney for its final review. And it's only until then that it will go to the town council. We're talking about months from now.
Yeah.
By the time the town council is presented with a recommended, updated, revised new ordinance.
and I would suspect, if I'm not mistaken, that even any member of the public who wanted to
Yes.
could read through and make recommendations for these changes. So
And
we are not special in that sense, except that we have been chosen by the council to look at these matters.
yes, and I'm glad you brought that up, because the process of the comprehensive plan, which would include this, is that we have to have meetings with the public so that they can provide the input. So that will be part of the process.
I would make a motion, just because the chairman can't, that the planning and zoning board adjourn.
All those in favor? Okay. So now we have
No obligation to leave. That way they don't have to stay if they're not revolved.
Or they could say.
Yeah, no requirement.
Well, I would as a note, encourage anybody on both boards to write those notes down, and let's process it through the city manager, through Victor.
Is there a specific variance request that we want to address first?
On the board of variances. He had,
On the agenda, it's the Southside Bay PUD. So,
Yes, but there's more than one variance.
yeah, oh, I thought you were talking about the individual.
Yeah,
sorry,
we would recommend that you take it one at a time.
so his first variance, was request, for a smaller lot size, which we didn't agree with, I mean, that, even as we, the city manager, I've heard city manager so much as the mayor, so, but
I know that the city engineer and the building official, they reviewed the 4 variances. And can we start with, which one do you want to start with first?
okay, the lot size.
So the two-
I don't have it in front of me,
Yeah.
Victor, I bring them.
One of them is,
I have your papers, sir.
one of them is a setback. Oh, yes.
Yes, the setback, so the setback, the 15 to 8,
The first one is rear setback variance request only. That's just the rear.
Yeah.
And they wanted to go from 15 feet, which is in the ordinance, to 8.
And was there any rationale behind the request?
No, I mean, I didn't put here, I don't know, in their presentation.
I don't think
there was
anything noted.
This allows efficient use of limited site depth, particularly where the geometry of the site and drainage requirements constrain building layout. Reducing the rear setback enables optimal spacing between buildings. It preserves front yard setbacks and drive areas without compromising building safety, aesthetics, or access to open space. Reason for-
as a building official, at the meeting, am I allowed to make a recommendation? Or,
So,
I would like to hear your concerns.
and let me, before you start, let me touch on, so what you read there, it implicated some areas of expertise, in other words, areas of particular expertise within the training and education of an engineer and a building official. And so it would be appropriate to, especially with that, there's one sentence in there about something about preserving safety.
Site drainage,
Yeah.
geometry, and building layout.
Well, there was something that you said a little later about preserving.
Preserves the front yard setbacks and driveway areas without compromising
Yeah.
building safety.
So that phrase right there, and all of it, but that one in particular to me, and that's something where you need expertise to tell you whether or not, the person agrees or not with the idea that changing that setback is not going to compromise. And so that's within an engineer's expertise. It's within Dewey's expertise. And so, hearing from them about that is something that will inform your decision. I think
I would have to agree with Mr. Bolts. I think 8 is a little much. I think at the minimum, 10 feet.
And may I ask why you feel that? What guides that impression?
To be honest with you, I want to stay in between. I don't want to really prolong this development from starting, and at the same time, I don't want to veer too far off from the ordinance. It's, and
Landscape.
you understand what I'm saying? The landscaping.
Yeah, where's the
And-
landscape?
we have a landscape.
Back in the day, it used to be
We do have a
35% of the lot would be open to the sky. Now we're down to 8 foot.
10%. 10%,
The logic referenced in that letter stated that it preserves the front setbacks. And my curiosity is if the request is not granted, then it simply makes the home smaller, the overall plot, the overall building area smaller, or does it mean they then come back with a different front size?
No, it will reduce the size of the.
So I understand that there's a willingness by city staff to accommodate to some degree. And in accordance with what the attorney mentioned earlier, not going to an excess, to deliberately try to stay close.
That's
to
where you
the
start
ordinance.
setting precedent.
Right.
Don't want to do that.
Yeah, that the ordinance is there for a reason, and to adjust, to make an adjustment is appropriate, but to make an excessive adjustment becomes problematic. So,
And I think one of the things that needs to be also, this was gonna be only present for this area. They weren't asking to change the variance for the city, just for this area, this development. Now, I don't think that there's a magic number to somebody having to come up with a 50-foot backyard. I think it was just something that was put on paper. There is nothing that will inhibit anything other than aesthetics. The green space area is something that's calculated, that's common area to everybody. It could include the backyard, but it's mostly considered only in the common areas of the subdivision. And so, again, I think it was just a number that's already put on a piece of paper.
And
it's
is
something
the
that
area-
they approved or disapproved or modified as to your all's.
and not looking at a map at this moment, is the area behind
Yeah,
their
this is just the
setbacks?
backyard. This is the
What
area,
goes, what's past that?
I think it's just the fence, the property line.
And a dish.
And a ditch, and
whatever-
that's
well,
where I was recalling, there was a ditch.
The dish. Let me ask you,
Yeah, the
Jose, if I
property
may
line,
ask,
the property line of a lot is the subdivided lot. That lot goes to the center of the ocean, and that's the backyard. But in this case, it's wherever the line stops for that lot, it's where the end of the backyard is.
So if they put that particular lot line in the middle of the ditch,
I don't know if it was in the middle of the ditch. I think it was, because that whole area was gonna be lit, because since it's wetlands, they cannot put the property line in the wetlands.
but the wetlands is part of their property.
Yeah, but it's not part of the subdivided lot.
So
well, it is
understanding-
actually, there's the lots closest to the bay, there's 3 or 4 lots, even on the, when we're asking for this setback requirement to be adjusted, is actually in the wetlands, and it is in their draft document, and it hasn't been addressed yet. Let me ask another question. Is this your general understanding of different developments that you're making this suggestion, or is it from our ordinance?
No, it's from the ordinance. The ordinance calls for 15. And
Okay.
somebody came up with a number 15. I do.
No, but you don't have a problem with it for just general use that you've seen in other places in the valley or in your practice, or is this based on what the city?
No, well, the development for this one is going to be townhomes. It's not, single family home, so that's the other consideration. The request is for a townhome lot, not for a residential. And residential lots usually.
So no, this 15-foot setback is for townhomes.
Right, and then if that's what,
That's why they're-
that's what calls for townhomes, and then that's what they came up on.
Well, as the attorney, can I make my certain points on this issue?
Yeah, that prevents you from
Okay.
discussing it.
With an 8-foot setback, number one, that's smaller than the required size of the bedroom, which is 9 by 10 by code. So that's already 1 foot shorter. Number two, 5 feet of the 8 feet is utility easement. And when you've got, what is it, 8 townhouses together, How does a firefighter jump the fence to get to the middle, to number 4?
There needs to be a breezeway in the middle of that building.
So,
Yeah, so there's no way to get to fight a fire. Number 3, half of those homes that they're talking about with that backyard setback are on the canal. 3 of which are actually overlapping the wetlands designation that's on their plan. And if there's an event such that the water is coming downstream so fast that it's going through, number one's going to go into these houses, or their fence is going to block it, and it's going to go across the canal into Paradise Cove. So then who's upset?
right, again, that is also, that is an issue for the fire marshal.
Yeah.
For him to, that's something that he's gonna look at, and the fire marshal that I know, that we have several for the county, and they're pretty by the book.
Yeah.
They go through, they're gonna come themselves
Right.
and look through that property. And mangroves, we've got GLO that has to be addressed. We've got the fire marshal. He's number one. He's got to look at it. He's going to approve it or not approve it. You know, then we have the Army Corps of Engineers. They're also, you know, so everything is, you know, those mangroves are protected. You know, so it's a letter. So as a firefighter jumping over a fence and not being able to get from one townhome to the next, all that kind of stuff, that's all going to be looked at by the fire marshal, by the Cameron County fire marshal.
Correct.
He's not
And
gonna
I
allow
understand that. I'm just asking our attorney, these are our basis for saying that this is part of the Board of Variance rejected
Why,
that
I would think that
variance request. For that,
the
these reasons.
8-foot length of fence would be no different than a 15-foot length of fence when it comes to going over it.
Well,
So I think that's,
might agree with that.
that portion's probably a moot point. But your other concerns, I think, I would take very seriously, and I appreciate you bringing them up. I don't know if there is, in the minds of other members, any other number of accommodation to this builder, or if there's no number or desire to accommodate them at all. I honestly don't know. So I'd love to hear from everybody. What number do you think is appropriate? If it's 15, it's 15. If it's 8, it's 8. If it's anything between.
Well, the other point that I didn't bring up on the same issue is, and this goes to all the variances, she's asking for smaller lots, the setback requirements side and back, to where we're 90% paving and building, 10% landscape. And my numbers may be wrong, plus or minus 2%. But that's what I've calculated out. As Terry said, the original ordinance, even for townhomes, was 35% open space, meaning a landscape area. And we haven't even talked about landscape, other than a quote in there that says it's a walkable community with some landscaped areas. It's not really that much compared to other stuff.
But it's a PNC issue.
Yeah,
So again,
right.
we're mixing things.
Are we?
Well, this is a.
That's part of the
Yeah,
concern.
based on what gets advised.
I mean, we don't have a landscape requirement in the zoning ordinance. Now you can, you talked a second ago about a requirement for a certain percentage of open space. I don't remember that in the ordinance, but if you read it, I mean, that could be a basis for it.
But Terry mentioned, Terry helped write the ordinance.
You're saying that we enforce the landscaping on single family residents, but we don't enforce it on a townhome?
They're defined differently.
What's up with that, Vivi?
Unfortunately, they are different. I'm going to be completely honest with you. Since I've started working here, actually, there hasn't been an apartment complex other than this fourplex.
Yeah.
That's here that has been built since I've started working here. I mean, I completely understand where you're coming from, but we don't really have anything that says anything specific to town ordinance, I mean, to townhomes.
That's one of the things we want to.
But you're,
So that's-
we're not,
You know,
being- right, you're not being asked though for a variance on requirements that don't exist. You're only being asked on the what's it do. In other words, whether or not you wanna grant them the ability to, step outside the bounds of the ordinance with regard to those distances and issues. If you want to take into account that it's going to have the impacts you already described, the difficulty of first responders to get in or out, drainage issues, it being out of character with the neighboring property, it being too much of the total distance required is being asked to be varied, the percentage that they're wanting to scale back is too high a percentage. All of those things are factors that you can take into account. But you don't have to take into account requirements that aren't in the ordinance that you're trying to manage, because you already got enough reasons to vote the way you want to vote. So yes, all those things that you were asking about, they're concerns that you can use to inform your decision on whether or not you're going to grant this applicant what's asking.
I still would love to hear from all the members if there is a number that they would like to vary it by, be that 1 foot, 0 feet, or all 7 feet, or 8 feet, whatever.
15.
For me, I would like, the recommendation of the city engineer and Mr. Dubious, who I,
So you would go with 10.
yes, that is her recommendation.
And what was that?
She said 10 feet. 7. 8.
Others?
Prefer to see a stay with 15.
I agree with 15. So anyone is free to make a motion to either grant, deny, or approve with conditions. It sounds like what would get approval is a denial because we're.
Can I ask one further question? Would the denial of this particular variance request create, in your mind, an excessive hardship that would totally interrupt this project?
An excessive hardship?
To who?
That's a high bar. I
To
know.
the investors? Is that the hardship you're talking about?
So,
Sure.
okay, so
Really?
may I be frank?
Wait,
Okay. To a certain extent, of course. So what's gonna, I feel like certain variances, I do understand, and I'm gonna, I don't know if you guys agree, 4 variances, that's a lot to be asking for. I do agree with that, that's too many. But like the 15-foot setback variance, to me, they're not, it's not a real big deal, and I feel as if we don't meet with variances like that, if we don't meet halfway, we're gonna end up getting, they're gonna lawyer up on us.
so are you saying this is the lesser of the request?
I don't know where that comes from.
May I suggest something, Mr.
That doesn't
Chairman?
make sense.
Whatever number you pick, whether or if it's 0, but let's say you throw out a number of 9, 10, whatever. If you were to go with that, provided that the fire marshal approves that, because you may be asking for 10, the fire marshal might say, you know what, no more, it has to be 12 feet. I mean, it has to be 15 feet.
Yeah.
That way you protect yourselves, that you did try to accommodate, but based on the fire marshal. That way.
And I'm wondering if this is the lesser of the variances,
I honestly believe that it is.
that I would suggest maybe 12.
Yeah.
Let me back up a second. That's only a misconception right away. Is the lesser of the variances?
I'm sorry.
It's the lesser of the variances. They also want the lots to be smaller.
Well, okay,
And
but that's,
now-
but again, now we're jumping to the other variances.
Yeah.
Before, but why don't,
I think they have equal weight. I just leave it.
well, no, there's no dispute, there's no dispute about equal weight, they're equally, but the thing is that in order to have a clear and protective, action by the board, and with the protection that if the fire marshal overrules everybody, then it may end up being a moot point. And the developer will see that this community is trying to work together. And
The council, what happened the last time, the council ended up, you remember,
That was
right?
another point I was gonna make. It doesn't really matter what we think. The councilmen are gonna vote whatever they wanna vote.
Your recommendations are. they're
Sometimes
important.
they like them, most of the time they don't.
They're important, but, you know, the
So,
garage one, I don't agree with that.
10 minutes.
okay, but what are the other three variances? The other one was,
Outside.
going for a small house.
Lot size.
Garage, garage.
That was garage site
I
variance.
can't hear
Minimum
them
lot
well enough.
size variance, and the last one was.
The garage
was
side.
it just three?
So the three others are,
So variance number one is rear setback variance request from 15 feet to 8 feet. Variance number two is garage size variance. Variance number three is minimum lot size variance. Variance number four is minimum lot width variance.
okay.
So it's only 4, it wasn't 5.
Let me ask on the overall lot size, if we were to grant in any way, shape or form, the rear setback one and not to grant the one on the lot side, would the lot otherwise have to get larger?
Now, the setback of the backyard is also, is already included.
It's
in the lot.
included in the lot.
Square foot.
Okay, and the garage one is specifically what?
So they want us to go from having two
You said
garages
one.
to one.
Two, basically.
With a remaining parking on the drive.
Yeah, with, according to the plans, they want two,
If I remember correctly,
two cars. in
the
front.
garage goes from 2 to 1, and then the driveway will
Two
go
cars.
2 additional cars to vehicles, so it would go to 3 vehicles total.
Yeah.
On the garage thing.
And
Yeah, the driveway would allow for two parking,
Yeah.
2 cars to
And
park and one in the garage.
that is a more substantive concern than the rear setback?
Yes.
Yeah.
Yeah, and I simply stated it during our planning and zoning, our board of variance meeting, is number one, you go to a single car garage, 9 times out of 10 it becomes a storage room.
Yeah.
It's not a place to park a car. Then you have 2 adults with 2 vehicles parked in the front of the house. And if, and this rolls over into the width change to a smaller lot, from what is it, 35 to 27?
25, 35 to 25.
35 to 25, okay. If I'm parking 2 cars, and I've got a 20-foot wide driveway, I've got 5 feet left. And I'm not gonna park anything but a smart car on the street.
They're
I
saying
don't
that
park it on the
there's no off-street parking in this community.
Yeah, there's,
Exactly.
So if you're gonna deny them, why are you letting the rest of the community
Ah,
not have
There's
off-street
no
parking?
off-street parking.
Well,
That's where the developers kind of, wait a minute, what's
but
he
that's
thinking?
where then we.
You can't
as-
park a car,
But then we, as the people that get paid to advise you,
okay?
we as the people that get paid to advise you, the attorney, the engineer, and myself, you know, if we know that we're gonna deny somebody what the whole community is denying,
Okay.
how can you defend that?
They're gonna come back and say it's a planned unit development, that's one of the things we're trying to get around.
Well, again, but the thing is that how can we say you must have off-street parking when we don't have it in the community?
Good.
That's a very difficult to defend.
Yeah, interesting.
so it's an HOA thing. It's an HOA thing, the golf course doesn't allow it, right? Lakewood doesn't allow it. It would be an HOA thing, they'd have to, not allow it. I don't agree. Truly, I don't agree with the, changing the double garage to one garage, because yes, it's gonna make the townhome, smaller from 35 to 25 feet, and I don't agree with that. So, as of the parking on the road, I'm not concerned about that at all, because the HOA hopefully, the HOA is not gonna allow it. Do we have a city ordinance against it? No, we don't. Only certain areas. The golf course doesn't allow it. Lakewood doesn't allow it, because the streets are smaller,
Yeah.
and stuff, so that's just.
So but you're saying that the golf course does not allow it, Lakewood doesn't allow it, but is that for the entire city?
It's
No.
not, it's not an ordinance, so
Okay.
if they do not,
Uh-huh.
enforce it or put in their HOA, rules or standards, it's like what Mr. Kirby was saying, we can't enforce it. It's not enforced, it's only enforced here in certain areas.
Yeah. I might be inclined to say it's 55 plus community, maybe. But, if, my wife has the ladies over, they're parking on the street. And you look at this development plan, there's no parking. Also, they're gonna be parking on 106.
I completely understand, but that is also something that's out of our hands until it's in ordinance.
Yeah.
And so.
And that's why we have a meeting.
So those are two, what are the three and number 4?
The lot width from 35 to 25.
Yeah, we discussed that. It's all together.
And what is your view, the two of you?
So I going from 35 to 25, I don't agree with it. Necessarily, I guess that would be the whole garage changing from a 2-car garage to single garage. But if we come to a middle ground on the setback, that's going to change the lot size to an extent anyways. So
Would it be appropriate for me to make a motion to reject the second, third, and fourth requests?
That would be a appropriate motion.
Well, you could also amend or say, we have a specific, as far as rejecting the request, we've already done that.
Well,
So do we do it?
Okay, I mean, it's back on the agenda, and that's a proper motion. If it gets a second, then you can do it.
Before I go any further, this lot width change.
Well,
we have
I'm
to
making
address
a motion to say no to changing the lot width, changing the garage size, and changing the overall lot size.
setback.
No, I'm leaving number 1 alone for the moment and trying to address 2, 3, and 4.
I'll
first.
second your motion. All those in favor?
Aye.
Aye.
So the motion was to deny the requested variances.
Not all.
2, 3, and 4.
Yeah.
That way it opens up request number 1 to contemplate the concern that was presented. If we entirely and overtly reject all of them, we could create some pseudo form of liability, not literally to the city, but in the sense that it would show a reticence by this board to work with them at all. And in that sense, is there a belief by the board members that there is any room for compromise on the first issue?
Yeah, for sure.
And then what is that room? And I personally, I'm not making a motion, but I'm suggesting 12 feet is as reasonable as I can be.
That's right. And it may change with the fire marshal.
Yes.
And I guess.
No, I think that's
exactly.
right.
The fire marshal is your protection.
That's good.
May I ask a question too? Do they, I
Yes,
don't know
sir.
if you saw this, weren't they asking for a narrower side setback? Well, these are townhouses, so they're joined, correct?
Yeah, they're doing.
So they're joined with a 2-hour wall or a 1-hour wall. They never
Yeah,
said
they were gonna have a firewall.
Yeah, they're.
a firewall to be a 1-hour or a 2-hour. So they didn't talk about fire sprinklers.
Yeah,
Right.
they have to have fire sprinklers, and they are. They
Good.
have to have.
They have to. Good,
They
good.
have to.
Yeah.
Really glad to hear that.
Okay.
So
Well, I'll make a motion to approve the setback to 12 feet.
I'll second.
all those in favor?
Aye.
Aye. Motion carries.
And like, Mr. Bull said, now we've opened the door for other.
Can you explain
But,
that?
and I think-
There's a, where it doesn't open the door.
So, Mr. Salazar, it's strictly only for that development. Everything goes, when it comes to some, a different development, anywhere else, start all over again.
So maybe it's a good idea to hear a motion from one of the board members that these apply only. Our vote only applies to this particular development. Should that be written in?
It wouldn't be necessary.
Yeah.
Wouldn't be
That's just
necessary.
legal standard. It's like I was saying, it's a fact-based analysis.
Yeah.
We look at every situation.
Yeah. And I thought, if I may, and I thought that at some point, they were asking for a narrowing of the side setback on the houses.
I think it was the other development,
Yeah.
right?
Or the other development.
It wasn't this.
I move to adjourn.
Second.
All those in favor?
Aye.
Reasonable.